Good morning, everyone. My name is Jordan Scopa, and I have the pleasure of welcoming you to Goodman's today. I'm a partner in the litigation department. We have Andy Harrington, Justine Johnston, and Ben Hackett with us today. I'm going to delay introductions for a moment. I'm going to start off with an apology. Duty unfortunately calls, and they're traveling for work this week, but I welcome you here on their behalf as well. Before I introduce the panel, there are some administrative issues that I've been entrusted to address. The first one is that for the lawyers who are here in the room, and I see many of you, this session does count for substantive hours for the Law Society CPD requirements. So everyone who's here in the room, as well as those joining us on the webinar, will receive a proof of attendance email after this session. And so please keep a copy of that email for audit purposes from the Law Society. And for those of you who are here, if you haven't signed the attendance sheet on your way into the room, please do on your way out. And with that administrative material out of the way, I am going to introduce our esteemed panel. So the gentleman to my right is Mr. Andy Harrington of the Brattle Group. He's a principal there. The Brattle Group is an economic consulting firm, and they specialize in providing expert evidence in litigation matters. Andy's been practicing for over 25 years, though he looks a little younger than that. And he's been qualified as an expert both before the Ontario Superior Court as well as the federal court as an expert in the quantification of IP damages. And Andy actually has recently authored a book on intellectual property remedies. You can contact him for a copy of the book. I had the privilege of reviewing it for him. One caveat for Andy today. Andy will be speaking here from his personal views, and the views that he expresses here today will not be the views of the Brattle Group. As a more general matter, when it comes to Andy from a personal perspective, having worked with Andy for a number of years over a number of different matters, I can tell you that there is no one I would rather have working with me, consulting both behind the scenes and in the courtroom, explaining some of the very challenging concepts of quantification to the court. And so I really appreciate Andy being here with us today. Next person beside Andy is Justine Johnston, and she's a member of our competition, antitrust, and foreign investment groups here at Goodman's. Justine's practice is very broad. It deals with all aspects of competition law, and she has advised very recently in some cases on cutting-edge questions that deal with intellectual property issues, and that's why we're very happy to have her here given the topic today. Last but not least, we have my partner in the litigation department here at Goodman's, Mr. Ben Hackett. Ben is a litigator. He's a very, very experienced trial lawyer. He may look like a young man, but he's done, as far as I can recall, 3 or 4 lengthy trials each year in intellectual property disputes in the federal court since he was called to the bar. And years ago, Ben also acted in a trial that raised competition law issues as well as intellectual property issues. And to this day, he continues to work with members of our competition law team on competition law matters. So welcome to our 3 panelists. And just some ground rules for today in terms of the way that we will be proceeding. What we're going to try to do is try to lay the foundation for a panel discussion. And while we're laying that foundation, I'm going to ask you to kindly hold back on questions. But once we launch into a more free-flowing discussion, after we lay this foundation, then I'll encourage you to jump in with any questions that you have, and someone will run at you with a microphone. So the way that we're going to break down the first part of our discussion is I'm going to ask Andy first to speak about IP issues in business. Then both Andy and Ben will talk a little bit about the nexus between IP in business and IP law. And then Ben and Justine will discuss the policy goals of IP and competition law and some of the potential both tensions and complements between those two areas. So Andy, I'm going to ask you to take it away.
Okay, thanks very much, Jordan. I'm going to start with a little bit of corporate finance, just to give a bit of background to people. Let's say you've got a business that has $10 million in assets. And let's say your business has a weighted average cost of capital. That's the cost that the required return that your investors want of, say, 10%. You have to generate a profit of $1 million just to justify the existence of the business. So you may think if you generate a profit of $500,000 that the business is profitable. It's not. It's actually suboptimal. It's worth more dead than alive. So you have to start with a minimum weighted average cost of capital return of $1 million. How do you get there? More importantly, if you just generate $1 million in profits, you're simply justifying your existence. The business is not generating any excess profit. It's not going to increase in value, and shareholders are frankly not going to be happy. So you have to generate a return of more than 10% to really justify an increase in value. How do you do that? Companies, to the competition lawyers in the room will hate to hear this, you need to escape the competition. You need to differentiate your company from the competition to justify why your customers will want to buy your product as compared to something else, or justify why your customers will be willing to pay a higher price for your product. And that's where IP comes into play. IP is a way of differentiating the company from the competition. And then once you have that IP, I'm going to get more into this a little bit later on. Once you have that IP, you want to build a moat around your fortress. You want to protect your IP, and this is where lawyers come into play, of using legal abilities to say, I not only have this IP, but I'm going to stop other companies from getting it, from copying it. Yeah. That's IP is in business. To start off, a company will usually have a combination of trade secrets, patents, some form of IP that it can differentiate itself. In time, not at the beginning, but in time, that IP will often morph into brand. If you've got a newly startup business, it may have a brand, but that brand's not its differentiating feature. Apple, on day one, no one knew what Apple was. Now, Apple stands for something. It stands for, when you buy the product, you expect a certain level of quality in the product, you expect a certain level of features, you expect a certain level of customer service if you ever have to go back to Apple. That's embodied in the brand, and now you'll pay a premium for the brand. That's not something that exists at the beginning. So that's really what IP is in business. It's a combination of legally protectable IP, but it's also a lot of what simply resides in the processes and best practices of how the business works. And I think that's how I'm going to sort of segue into the next slide. Companies don't always appreciate the extent to which their IP goes down the elevator at 5 o'clock every afternoon, or 6 o'clock, or 7 o'clock, whatever time they leave. So if you ask yourself the question of, for business leaders in the room or on the web, if you ask yourself the question, what happens, or does it keep you awake at night, the thought that person X is going to get hit by a bus on their way home tonight?
That should keep you awake at night.
That should keep you awake.
That should not be a positive.
Hopefully if you're not person X. But if person X is someone else in the organization, if there is a real concern that you worry about the ability of your business to handle person X getting hit by a bus, and I'm going to keep focusing on hit by a bus to distinguish from what I'm going to come to later, then that tells you about employee concentration risk, about one person. That means that you as a corporation or your business is dependent on that person, and the IP that resides in that person's head is not actually a corporate asset. It's that employee's asset. If you ask yourself the question of the last time you hired a person into a senior role, how easily did that person just slot in and know exactly what their job responsibilities were, how their role performed, what their processes were, who they had to report to, what information they got, what information they received. If that was a seamless exercise, then you know that the processes around that responsibility are a corporate asset. They don't reside in that person's head. So the answers to those two questions will let you know the extent to which the company is well organized in terms of documenting all the processes, all the knowledge that's in the people's heads as a corporate asset, as opposed to an asset that goes down the elevator at 5 o'clock at night. Now let's change the example. Let's say person X, instead of getting hit by a bus, leaves and goes to a competitor. Is that a bigger risk for you than them getting hit by a bus? If that's the case, now you've got to worry about, is that knowledge transferable, and how are you going to ensure that that knowledge doesn't move to your competitor and suddenly the advantage that you had is gone? That's the next question. And then lastly, sticking to person X, who's a very important person. If person X invents something in the job and it's groundbreaking, it completely changes the way your business operates and really helps distinguish you from the competitor, and that's patentable technology. Is that patent yours, or does that patent belong to person X? If you know the answer to that question, that's good. But if you don't know the answer to that question, then you need to perhaps revisit your employment agreements to make sure if anything that's developed belongs to the corporation, or again belongs to person X. So these are all just examples of some of the IP. If you're comfortable with all of the examples of that and say, no, person X is good, I know exactly what they do, I can hire people, I know if they invent something, it belongs to me, then all of the assets are corporate assets as opposed to individual assets. If they're corporate assets, now you have the ability to decide what to do with them. Is it a trade secret? The Coke recipe was a classic trade secret. Is it something you decide you want to patent? And the distinction as to whether you want to keep something as a trade secret versus patented, if it can be easily worked around or recreated by a competitor, you probably want to patent it as opposed to keep it as a trade secret. But if you have all of that and you can decide what to do with it, then that's all the IP that belongs in the business and makes the business operate and generate those returns in excess of 10%. And with that, I'll hand you over to Ben.
Okay, so my role in this piece is to talk about, well, how can the law help? And the kind of key ways in which the law can help is first in setting out for a company, the preservation or the acquisition of intellectual property, and downstream from that, the ability to protect and enforce that intellectual property if it crystallizes into a property right. So first, to look at the front end with respect to agreements, one of the key aspects that people don't realize is that you might not actually own the intellectual property of your employees. So the default position at common law is, unless your employees are specifically employed for the purpose of innovating, they own their own IP. And the way in which you protect for that, as Andy said, is through employment agreements. So that's one very significant way in which the law can help, is through allowing you to arrange your affairs to ensure that you indeed own the intellectual property of your employees. Second, and this is where it gets a bit more interesting and can be more complicated, is with respect to defining the parameters through engagement with third parties over who owns intellectual property. And this is, in business, this really becomes a bit of a tension. You know, if you want to engage in a joint venture with someone in a large, very formalized way, then it's expected that there will be large formal agreements that relate to that. If you're talking about operating a much more dynamic space with smaller players, the idea of, before we all sit down over some beer at whatever it is, a foosball table, and start thinking about who's going to do what and how are we going to collaborate, the idea that you all come with an enormous stack of paper that delineate who owns what coming in, who owns what through that collaboration, and who owns what coming out, that might be a bigger ask. And so how the law helps is ideally through those large agreements, or ultimately through trying to sort out after the fact, who was the contributor to the IP through that hackathon, or whatever the case might be. And then in addition, once you have something worthy of protection, once you have intellectual property in some form, be it a trade secret or something that you want to ultimately patent, you have to start to be careful about who you share that intellectual property with. So from a trade secret perspective, once it's the cat's out of the bag, it's not a secret anymore. And your ability to protect a trade secret, as Andy said, is by people not being able to figure it out so readily. And when you want to share that secret with someone, you need contractual protections in place to ensure that, one, hopefully they keep it secret, and two, if they don't, that you have relief available to you, because it's not necessarily something you otherwise have an ability to recover for. The other side of it is when you want to share your information with potential investors or other collaborators to ensure that they can't then take your information and run with it, or if you do want to ultimately seek patent protection, public disclosure is what really sets the clock ticking for having to come to the patent office and seek a patent. So non-disclosure agreements are a very important tool in being able to talk to people early on in the piece about your technology, trying to get investment, trying to get people excited about what you're doing without kind of playing your hand and forcing you to run to the patent office at a certain point in time. Because if you're a large established company, that's one thing. If you're a small startup, that's a very expensive proposition, and you probably want to be spending your cash flow on other things early on in your development piece. So that's the agreement side of things. With respect to what you can do to create rights in your intellectual property, then you're into the categories that most people, I think, know about or are familiar with. That is seeking a patent for a new and useful innovation or an improvement on one, trademarks for unique combinations of sound design that distinguish your good or service, and copyright, which is a common law right, but you can register it also by statute for the production, reproduction, or publication of original literary, artistic, dramatic, or musical work. And in the business context where that really comes into play, or frequently comes into play, is in the modern day through software. A lot of protection for software is through copyright. You can patent aspects of it, business methods, but the most direct protection comes through copyright. And finally, that's a piece of paper that you have that recognizes you have a right, but how the law also helps is in aiding you in enforcing those rights. I'm a litigator, so one good way is to sue people or be sued, but also through licensing agreements, through deterring market entry, the fear of suit, and how you structure your intellectual property protection has significant implications for your ability to seek relief and to deter people from competing with you. So the next slide is to kind of take a step back and say, well, what are the policy goals that inform this intellectual property protection? And then to give Justine an opportunity to explain how they don't necessarily always play nice with competition law. And at a bedrock principle, the central thesis of intellectual property protection is that we want to coax useful inventions into the public domain, and that we do that through offering a bait, and that bait being a limited term monopoly for disclosure. And the idea behind that is really, they're related but twofold. One is that innovation is expensive, and we want to motivate people to engage in that innovation. And if they know that there's a potential pot of that expensive and risky behavior. And the second is that we view innovation as synergistic, and that people can improve upon what other people have disclosed, and so that by motivating disclosure, other actors can take that information while it's still under patent protection, for example, and improve upon it, and that there'll be more dynamic innovation. And recently gave a lecture in a different forum where, we question whether that actually is, in the modern era, something that still holds, but that is the paradigm within which we operate. That's what is the fundamental principles behind intellectual property law.
Perfect. So moving over to the competition law part of the slide. So what is competition law? So competition law is a federal law of general application that protects Canadians and businesses from agreements, mergers, or other business practices that can potentially have a negative effect on competition and competitive processes. So competition law does apply to monopolies, which exist in all areas of our economy. And intellectual property is one type of monopoly that competition law applies to. So there's kind of an inherent tension between competition law and intellectual property, in that intellectual property rights grant the IP holder an exclusive set of rights, but competition law imposes overall limits on the activities that IP holders may engage in, so that it prevents any potentially anti-competitive effects in the market. It goes back to this kind of complementary policy goals. So while competition law recognizes that IP rights are important and they're necessary in the economy to push for companies to innovate and create new products, it also works to ensure that companies are exposed to continuous competition from their rivals, which also pushes companies to innovate and create new products. So there's kind of this tension between granting exclusive property rights, but then having limits on those rights so that competitors can't be excluded from a market to prevent competition.
So having laid the foundation of some of the basic principles of IP and competition law and some of the tensions between the two, we're now going to move to the part of our discussion that is hopefully a little bit more free-flowing for all of you. We're going to encourage you to jump in and ask questions of our panelists. I'm going to put the first one out there, and you'll see a recurring theme of the questions that are going to be posed is dealing with this tension between IP and competition, and thinking a little bit more about how they can in fact be complementary policies. So Andy, I'm going to ask you to talk a little bit more. You've touched on this already, but talk a little bit more about the typical ways that businesses use IP to actually tangibly enhance their profits.
Certainly. There will be a bit of a repetition to what I said earlier. If you think about the value of a business, it's a function of two things. It's a function of how much profit is the business going to generate, and how reliably predictable is that profit. So, for example, you may have a company that generates $1 million of profit every year, and you know it's exactly $1 million of profit every year. If that was absolutely guaranteed certain as Bank of Canada bonds, then that company would be worth a significant multiple of the $1 million of profit. But if it generated on average $1 million of profit, but it was highly volatile, sometimes some years it was losses, some years it was profits, even if it averaged $1 million, that's high volatility. That's called beta from an investment perspective, and that will be worth a significantly lower multiple of the $1 million average profit. So to maximize value, companies want to do two things. They want to increase the profits, and they also want to secure the predictability of those profits to multiply, to get a higher multiple. And these are both areas where IP comes in. It's higher profits and protecting those profits, and sometimes people refer to that as a sword and a shield. I personally like Warren Buffett's metaphor, which is around the moat. He liked to invest in companies that had a very broad moat that protected them. And if you think about the sword as the ability to use patents and other internal technology of the company to increase the size of the fortress, and then you use protective patents, you use brand, You use litigation to expand the depth and the breadth of the moat around the business to protect those profits and make sure that they are more likely to be predictable and certain in the future to increase the multiple that the businesses trade at. So it's both an offensive value and a defensive value. And that's what IP is all about.
Ben, I'm going to ask you to weigh in on getting into more specifics, thinking about different kinds of businesses, both businesses that are well established and businesses that are starting up. What are the different types of specific patenting strategies that businesses can use?
Sure. So I guess, as you foreshadowed in your question, a lot of this kind of depends upon budget and where a company is in its overall life cycle. Taking a lot of these actions costs money, and how that fits in with your overall business model obviously depends upon how much funds you have and your ability to engage all this. So kind of with respect to, for example, patent protection, there's kind of different ways to think about it. You think about breadth of protection and managing also a life cycle. And so what do I mean by that? Well, kind of the core of it is you want to have protection for what you're doing and what you believe you're going to want to do into the future. They kind of protecting what your core asset that way. But what you want to do, and maybe this isn't a good thing to say beside a competition lawyer, but what you also want to do is think about how broadly can you occupy that space. So there's kind of two ways that people think about doing that. One is through a broader patent portfolio. So I'm not going to just innovate to protect the core of what I want to do, but I'm going to continue to innovate to protect a larger cloud around what I want to do. I can't understand the castle perfectly. I don't know if that's like a fortress wall or a bigger moat, whatever it is, but the idea is to make it harder for people to come and do something very similar to what I'm doing. Another way to do that, though, a cheaper way, but it doesn't have the ability down the road to get greater value out of it, is to make it harder for other people to patent. So in pharmaceutical context, what does that mean? That means I'm going to discover a drug, I'm going to try and commercialize a particular compound, but I'm going to publish all about everything that I can think of that's related to that. And so it's going to be hard for my competitors to come up with a Me Too kind of drug. In other spaces, I'm going to make parts of what I do open source, and I'm going to make it really hard for my competitors to exclude me, and I'm going to make it hard for other people to build their own fortress. So that's kind of thinking about it laterally. What's the breadth of my protection or the inability of others to come into what I'm doing? The other dimension is to think about life cycle management, because from a patent perspective, what you kind of think about as the typical patented idea is some breakthrough, some revolutionary technology that no one's thought of before, and I'm going to go get a patent for that. But the reality of patenting is that that's not just going to be one patent. I'm going to think about I'm going to improve that. I'm going to think about innovations that surround that one core invention. I'm going to improve the process for making it. I'm going to think about a new business method of how to better commercialize it. And I'm not going to get all those patents on day one. I'm going to think about a way to stagger my patents to enhance my ability to protect what I've come up with for a longer period of time. And you might imagine that first patent is really strong. It's going to be very hard to attack that, assuming that you've done a good job about drafting it properly and prosecuting it. And as you move through those kind of further innovations and protections, that those might be more susceptible to attack. But that's a second strategy. Perhaps it's obscured through the castle metaphor, but another thing to think about is you don't necessarily innovate for the purposes of for commercializing your technology directly. So a lot of companies think about using intellectual property as a revenue stream through licensing and other commercial arrangements. So that's something also that you can be thinking of. So it's not necessarily I'm just going to create a bubble around myself and then use that to exclude others, but some companies say, you know what, I've gone down this road. I, for whatever reason, don't want to commercialize this, but I can now extract significant rents from others who are desirous of using my portfolio. So those are kind of in a nutshell, the basic strategies that people engage in.
So Ben, I just had a follow-up question. It looks like Andy may have something too. In terms of this idea of life cycle management, just at a basic, simple level, what are the timelines that we have to be thinking about under the Patent Act in terms of filing and length of monopoly that come into building that strategy?
So I guess I'll give the easy answer, which is that it's 20-year monopoly, and for copyright it's substantially longer. I think it's 50 years after the life of the last contributor to the work. But that's from when you go in and you stake your claim. So the pharmaceutical context, people like to say it takes 10 years to bring a product to market. So you're looking at 10 years or so of patent life, and that's not satisfactory for some. And so managing your life cycle involves thinking down the road in a substantial way. I guess the one thing I failed to say before is that if you don't have a lot of money, a lot of times what you're really thinking about is, I want to have patents so that I can readily convince investors that I have something of value. So a lot of times you're talking about, I'm going to go talk to VCs, and I don't want to just be another idea. I want to show them that I have tangible assets that I can realize value on, and that's how I'm going to get maximum money for my startup. So that's another angle that I should have mentioned.
Andy, you wanted to add something?
Yeah, I just actually want to add something to what Ben was talking about and highlight that the decision to use your IP yourself versus license it out is not mutually exclusive. And the best example here is really Disney, which has all of the IP around the movies and everything that it does, but it in fact generates roughly 30% of its profits from licensing that out to other companies to do manufacturing. So you can actually do both. Sorry.
So Justine, I've heard a lot from Andy and Ben in terms of using IP to basically keep other people out of your market and to keep competition away so that you can enhance your profits. Can you tell us a little bit about what the competition law implications of taking those kind of tactics can be?
Yeah, absolutely. So going back to our first principles, so competition law does recognize IP monopolies and that IP holders have a right to exclude their rivals from a market. But because you're a monopolist, competition law says that you have a special responsibility to use your market power in a way that doesn't substantially lessen competition in a market. And since engaging in exclusive strategies may negatively impact competition, competition law is concerned about some of the strategies that Ben talked about because it does exclude your competition and can have negative effects for competition or for consumers in Canada. So two examples that Ben touched on that I'll kind of illustrate the competition concerns around are patent thickets and life cycle management. So with patent thickets, what is a patent thicket? So a patent thicket exists where a company owns multiple patents or patents broadly around an invention for the purposes of being able to make many infringement claims against its rivals to keep its rivals out of a market, or creating barriers that would, or patenting to create barriers that would prevent a rival to access the market to begin with, as well as preventing rivals from designing around your patents to get to make it up an alternative. So because patent thickets work to exclude your rivals from a particular product market, it's not inherently contrary or a contravention of competition law to set up these patent patent thickets, but you just need to be conscientious about how you're setting up the thickets and your business strategy around it. So you need to know that even if you're setting up a patent thicket, competition law may create some vulnerabilities around it, or you may not be able to enforce all of your patents because of the overall competitive effect that it has on the market. And so moving to the second example for lifecycle management. So competition law does have concerns around the timing of when you're making your patent filings. So where new patents are filed to extend the protections of a particular product that implements a patent, competition law will be concerned. And so this usually arises, or the issues in competition law usually arise where the new patent is around, or doesn't have the new patent doesn't have as much novelty as the original patent. So Ben's example of the pharmaceutical context is a good one, and the competition law issues have often come up where, for example, a new aspect of how medicine is formulated in a pill has been patented, but the actual active ingredient of the pill hasn't changed. And so competition law would be concerned about this because the life cycle patenting strategy has the ability to slow down entry from a generic into the product market. And so in this example, it's easy to think about, so if a branded company is selling drug X for $1,000 a pill, and it's able to continually bring new patents that extends its monopoly rights and preventing generics from entering the market, that it can continue to charge the $1,000 per pill beyond the initial 20-year patent period. And so without generic entry, the price of the drug doesn't come down, and consumers and the provincial governments are paying more for their drugs over a longer period of time than would otherwise be, they would be able to under the original 20-year period.
So Justine, perhaps it's my failing because I'm a little more involved in the pharmaceutical sphere, and so I can relate to the issue of life cycle management a little bit better. But taking a step back to patent thickets, could you give the members of our audience some examples of industries or popular examples where this issue comes to the fore?
So I think I would think about it in, again, in the pharmaceutical context would be a good example. So if you have, kind of similarly around the life cycle management, if you have different aspects of a pill, but you are patenting all of those aspects at the same time and just making it more difficult to be able to create a new drug or to create a new drug that can deliver medicine. Another example would be in the technology sector where you have a particular product that maybe implements some type of IP, and then around the product, the downstream product, you patent around that area as well.
Okay, thank you.
I think the very structure of a patent is kind of a thicket in and of itself, right? The way that you claim a monopoly, typically it's a cascading series of claims, the first claim being the broadest, perhaps the most susceptible to attack, and walking your way all around, way down to your narrowest claim. And so, frankly, almost any patent is in and of itself a bit of a thicket, in that it's rare that a patentee commercializes the full scope of its first claim. You know, it's the most broad or amorphously described business method, or in the case of the Viagra patent, it was a quintillion claims in the first claim. That's probably not, Pfizer's not out there selling a quintillion different ED drugs. So there's that inherently in the patents themselves, and then you kind of branch out to think about, okay, well, a quintillion's not enough. I want a series of quintillions so that people can't get around that.
So perhaps unsurprisingly, I'm going to try to steer this conversation over to litigation and what happens in litigation. So Ben, I'm going to ask you the simplest question, which is why bother to litigate at all in the IP context? What are you trying to do through litigation with your IP?
You do it because it's fun. No, sorry. So the kind of basic reasons to litigate are either to try and recover for having been harmed, having someone eroded the value of your IP, be it to recover lost sales that you otherwise could have made, or to try and disgorge, to get at the profits that someone who's appropriating your technology has made. And the second is to stop people from doing that. So in the short term, to try and move to court and get an injunction to prevent a person from continuing, or a firm from continuing to operate, or in the long run to have a court order a permanent injunction to stop that person from continuing that conduct on kind of on a go-forward basis. And I guess, well, I encourage you all to think about litigating IP as an IP litigator. What, as part of that decision, you kind of have to recognize that litigation is really the true test of the strength of intellectual property. So when you prosecute a patent, depending on the day of the week, you'll be asked a series of questions by a patent examiner. You may or may not have to give compelling answers to that, and you have your patent. But not all patents are created equal. There's a lot of shop talk where people like to send around, can you believe that this issued? Novel application of a chair, right? Really basic. My favorite is a napkin ring. A napkin ring with a patent number printed on the inside that's almost as much ink as it is paper. And that's probably a really good patent, but it has very narrow claims. But there also are broad patents out there that are not so strong. So when you sue someone or you threaten suit, that's all laid to bear. And so you're only going to get damages, you're only going to get an injunction if your patent withstands challenge. And so I guess one of the key decisions you have to make is, do I want to continue to use my IP as a saber and rattle it, or do I want to go to battle and try and get direct relief using that intellectual property? So those, I guess, are the reasons why you litigate.
So at a high level, it sounds like we have kind of two things we're thinking about: getting an injunction to keep people out of the space, and otherwise trying to collect a financial remedy of some sort for the IP. So focusing on injunctions for a moment, Ben, what are the factors when we actually have to go to court to try to get an injunction? What are the factors that we as lawyers need to be thinking about, but more importantly, that businesses need to be thinking about when they're thinking about even taking that step, and whether it's a worthwhile step?
So when you talk about injunctions, you kind of have to distinguish injunctions at the start of or in the course of litigation versus injunctions at the end of litigation. And the ability to get one or the other is very different. So, in fact, I think one of the first cases that Andy and I worked on together was back in 2006, and in the context of a interlocutory injunction. And
Your memory's better than mine.
I remember it. I was on the other side.
So the test there is for intellectual property is no different than it is for commercial litigation, which is that you need to have a serious issue to be tried, have to demonstrate irreparable harm, and the balance of convenience has to favor the grant of an injunction. It's the RJR test. And there's been a bit of a movement in the courts recently where what I would otherwise say is a little softer. What I'd otherwise say is it's really hard to get, and the real point at which most people fall down is showing irreparable harm. So you have to essentially make it a case that you're not going to be able to be made whole at the end of the day through the monetary rewards of the court and the ultimate injunction of a court. So that's something that's difficult to make out in the normal course, in particular if you're in the business of selling a good or a service, where usually you can estimate what the market was. You can see what the market was before, you can estimate what the market would have been had this competitor not been there, and then hire someone good at figuring out what your lost profits were in that context. There's been a bit of a softening as of late, and we could talk a long time about that. So I'll just kind of put a little asterisk out there and say courts seem to be softening a little bit on the irreparable harm requirement. There's been a greater recognition of kind of softer losses, but the short kind of take-home message is they're hard to get, they're typically hard fought, and most often the way you get them in the short run is in kind of unopposed sorts of cases, not the kind of big battle royale patent disputes. So at the end of the day, it's a lot easier to get a permanent injunction, assuming that your patent, talking about patents, hasn't expired. You know, if the lawsuit is near the end of your patent life, or it takes a really long time to litigate, which doesn't happen so often these days, but 15 years ago was the case. And in fact, Jordan and I are still litigating some cases that started, before we were in law school, sort of thing.
Before high school.
I think when I started at the firm in 2006, the first case I was on was in 1994, commenced litigation. So that doesn't happen so much anymore, but there are those legacy cases. And by and large, if your intellectual property rights are recognized by the court, you have a pretty strong ability to exclude the person who's infringing upon them. There are some erosions on that. In the United States, there was a eBay case that sought to apply the same sort of American version of the RJR test and say it's not something you get kind of as of right, and you have to meet the test. We've tried that a couple of times in the Canadian context and haven't yet got that to work as a defendant. And I guess the strongest ability as a company you will have to ensure you get a permanent injunction is to be working your IP. So the courts aren't as keen to give a permanent injunction to stop other people from working your IP if you yourself aren't working it. And in that context, your remedy is probably going to be some sort of a royalty. And so the infringer may be able to muster some sort of an argument that says, well, you're not working it. We've quantified what this cost of working your IP is, so don't enjoin me, but I still have to continue to pay these rights. And then you can argument as to whether we're essentially going to compel a license in that context indirectly through the courts. But by and large, hard at the start, much simpler once you've succeeded in your litigation.
So turning then away from injunctions and thinking a little bit more about financial remedies, Andy, can you explain for us the difference between a patentee seeking damages as compared to seeking an accounting of an infringer's profits?
Okay, certainly. Just to play lawyer for 1 second, just to clear something up. The fact that a patent was issued doesn't necessarily mean a patent is valid. So you go to court and assess the validity of the patent. So let's assume that you're successful and the patent is found to be valid. And speaking with patents for a moment, I understand, again, playing lawyer, that damages are a right of the plaintiff, whereas an accounting of profits is something that the plaintiff can seek, but is not necessarily automatically entitled to. Pen?
Yes.
Okay. There we go. So just to introduce that. So damages and profits are similar in that they both try and restore the party to the position that they would have been in had the wrong not occurred. The difference is that the damages are intended to restore the plaintiff to the position it would have been in. An accounting of profits is intended to restore the defendant to the position it would have been in. So if the plaintiff can prove that it would have lost profits, it lost sales, it would have made more profits, so it practiced the patent, and if it's able to prove that, it will get its lost profits. If the plaintiff does not practice the patent, or is not able to demonstrate that it would have made the sales the defendant made, then it gets a reasonable royalty. Those are damages. An accounting of profits essentially requires the defendant to disgorge the incremental profit that it obtained as a result of its wrongful act.
Okay, thanks, Andy. I guess getting into more of the nitty-gritty details of damages and an accounting of profits, Andy, I'm going to ask you to walk us through some of the different factors that influence those types of awards. And I know a hot topic these days is non-infringing alternatives. So as you're explaining, if you can walk us through what those are and how they play a role in both assessments, that would be helpful.
Okay. So to try and restore the party to the position it would have been in, the real objective, the starting point, is to understand what actually happened and what would have happened, what the world would have looked like, and we refer to that colloquially as the but-for world. So but for the wrongful act, what would the world have looked like? And a lot of time is spent understanding what the industry looked like, what other competitors were, what other substitute products. If you're in a pharmaceutical world, it's actually a little bit unique animal, and frankly, in many ways, the easiest way, because if you have a patent on an API on a product, if that patent is found to be valid, no one else can sell. So whatever sales the generic made would have been made by the plaintiff, the patentee. And that's essentially the easiest way. What happens if you've got an industry where you have 5 participants and one of them is found to have infringed? That doesn't mean that the sales that infringer made would necessarily have gone to the plaintiff. They may have gone to other companies in the industry. So understanding these industry dynamics, understanding all of the unique features of all of the separate products, what was of demand, requires some complicated economic analysis to try and understand the but-for world. Now, if there is no non-infringing alternative, let's stick to that example. So the defendant, if they didn't infringe, could not have entered the market. Then instead of having 5 competitors in the market, you would have had 4, and the world would look one way. If, however, the defendant had some other non-infringing alternative that didn't have this one feature, the infringing feature, but had enough other features that would still have been of interest to customers, then there would still have been 5 competitors in the market. The customers of that company that always bought from that company may still have bought from that company. So in other words, there would have been no lost sales of the plaintiff in that instance. So to try and understand the but-for world, you have to understand, did the defendant have available to it a non-infringing alternative? So then again, to focus on the damages, if you understand that, figure out the lost sales, then because maybe some of the sales may have gone to the plaintiff, those would be lost profit damages, and there'd be reasonable royalties on the rest. If all of the sales would still have gone, then they would still get lost profit damages and no reasonable royalty. Same thing on the accounting of profits, looking at the defendant. Maybe they may have made all of the same sales, but it would have cost them more to manufacture the product, or they may not have charged as high a price. So they had incremental profits that they made, even if they would have made all of the sales. That's the incremental profits that the defendant would have to disgorge so as to get back to the position it would have been in, but for the wrong.
Thanks, Andy. That's very helpful.
Sufficiently complicated.
Ben, do you have anything to add from the litigator's perspective?
Of course, but maybe just to take a step back first, Andy talked about reasonable royalties, and I think it's worth kind of just dwelling on this point very briefly because it sets up what probably going to talk about in a little bit, is that, and comes back to, why get a patent? Why not just try and keep a trade secret if you can? And in patent law, the law recognizes a right to damage even where you haven't lost anything. So because you've taken an intellectual property right, if you're found to infringe a valid patent, the court awards a royalty for sales that you wouldn't have otherwise made as the patentee. So that's what Andy's talking about when he's talking about a reasonable royalty. So imagine an instance where you don't lose any sales because some other competitor would have made all the sales. Had that infringement not occurred, you still get a royalty. And that's what the court is then trying to figure out. So just to kind of unpack that a little bit, in the profits context, if you're trying to disgorge profits, and the answer is, well, there were no profits on account of the invention, there is no recovery. And in contrast, in damages, if you wouldn't have lost anything, you still have this royalty that needs to be figured out. So that's just maybe something to get out of the way at the outset. And then with respect to what's the litigator's perspective on damages and profits and what it all means. We spent a lot of time at Goodman's litigating the issue of non-infringing alternative, trying to develop it into a robust body of law. The kind of fountainhead case was a profits case, Monsanto and Schmeiser in the Supreme Court. And so it's been a real battle to try and take those concepts and first port them into the damage context, which we have done, and now to kind of then take, frankly, the damage of that and have it make sense again for profits. And I guess the things to think about are what the court's going to be asking is, would you have used this non-infringing technology in the but-for world, and could you have? So it's a twofold question, would and could, and that at present at least applies both for damages where, you know, notionally that makes sense, but for something, what would you and could you have done? But it also applies in the profits context, which doesn't perhaps jive perfectly with this idea that what we're trying to do is value a patent, but that's the jurisprudence. And another thing that the courts really dwell on now is whether this alternative conduct is a true substitute. So those two aspects are really where litigants tend to fall down. So would and could, there's a recent case that just went through the Court of Appeal where the patented technology was a better way of fueling tankers, a hot swapping way, and the court found that had you not infringed, you wouldn't have gone back to the old way because it was dangerous and you didn't want to expose your employees to that risk. And so notwithstanding there's this notional technology out there, and in fact the technology that the company used to use, they weren't able to avail themselves of a non-infringing alternative. Another context in which this has not worked, I'm going to try to not talk about cases where I've been involved in where it hasn't worked because that's not as much fun, is in context where the court or the litigants accept that the alternate technology isn't close enough to the patented technology to be deemed a substitute. And so in kind of the plastics context, that's been the case where kind of commercial commoditized resin hasn't been viewed as being a substitute for this innovative polymer, notwithstanding that everyone accepted that had you not infringed, you would have sold the commoditized resin. So what's the litigation perspective is to say that this is kind of a cool thing to talk about, but the devil's truly in the details. And so if you're not yet in litigation and you're engaging in decisions as how to act in the market and how you're going to plan your business, it's really valuable if you ultimately come to suit to have thought about these issues. Because where, in my experience, I've had trouble as part of a team proving non-infringing alternatives is where they were kind of canvassed but then left, and so the court comes and says, if it's such a great thing, why didn't you do it? And you'd love to have documents or a thinking that is contemporaneous that explains why not, so that it doesn't look like it's a bunch of smart lawyers and experts after the fact concocting some sort of a reason why you shouldn't have to pay for your damages. So it sounds super technical to talk about non-infringing alternatives. It sounds like something when you're not in a lawsuit, what do I care about? The lawyers will figure that out later. But the reality is, it's a really valuable argument as a defendant because some cases the swing is 100%. It just, it turns out that, to use one of the cases I'm involved in, you manufactured in Canada, but you could have done it in another jurisdiction, cheaper. A company has a desire to employ Canadians and takes a risk because of that, but otherwise could have done it on a public market. And so, that's a difference between $100 million or not paying costs of a litigation. And how well you're able to marshal that defense really turns on what documents you have before the litigation was even started. So it's frankly a really important thing to think about. You probably don't want to. It's kind of like telling your kids to brush their teeth every night, but it's the thing that can really make the difference in a litigation down the road.
Justine, we've heard a lot from Andy and
Could I just jump in
Absolutely.
on that? Sorry. I was going to pick up on a few things. You spoke about hot refueling, and I had flashbacks to that because I did testify in that case. So I'm not going to dwell into the details, but that's a really interesting example of how the court interprets the would have and could have, because it is a very high bar to demonstrate the would have and could have there. But the question on you also mentioned the value of a patent, and my ears picked up at the term value. The value of a patent to a corporation is really the incremental value as compared to the value of the business if they didn't have the patent. So if you think about, I've got a business value, I don't have a patent, I can make sales, but when I get this additional patent, the value of my business goes up. And it's the incremental value of that patent, of the business, which is the value of the patent. And that actually really aligns well when you're doing a disgorgement of profits. If you take into account the non-infringing alternative, then you're simply disgorging that incremental value, and it gets you back down to the value of the business without. So you really need to take into account a non-infringing alternative if you want to align with the principles of value. If you don't, then you essentially include a punitive aspect in the disgorgement. Sorry.
Thanks, Andy. No, we appreciate that. Justine, we've heard a lot from Andy and Ben in terms of these wonderful remedies that IP can give you if you are an IP holder, and also some of the defenses that you can muster if you're defending an IP suit. What can competition law do for the people in this room and their businesses? Can competition law help enforce a remedy or defend against some of these IP remedies?
So there's a good side and a bad side to it. So for IP holders whose rights are being infringed, unfortunately, no, competition law cannot really help you with your remedy. So in Canada, competition law remedies in this area are public facing. So only the Commissioner of Competition can go to, can investigate, and if they find that there's an abuse of dominance or a substantial lessening of competition in a particular area, apply to the competition tribunal for a remedy. And in those instances, the remedy that the Commissioner of Competition would be seeking would be an order prohibiting the anti-competitive conduct, which would restore competition to the market. So it's an overall public remedy. And then also there's the possibility of an administrative monetary penalty or an AMP. So AMPs are not cheap. The first for a first offense, they're $10 million. That can be up to $10 million. And for a second offense, it can be $15 million. So the remedies, if your IP is infringed, are really publicly facing. The Commissioner is concerned about restoring competition in Canada generally, not the damages that the private parties have themselves experienced. But on the flip side to that, if you're a private party and you are being affected by exclusionary conduct, so if you are an IP implementer, for example, and you're unable to get a license or or pay a royalty to be able to use IP, or if you are using IP in a downstream product and you're not able to make your product economically because an upstream IP holder, for example, is not licensing on fair terms, you have the ability to go to the Competition Bureau and make a formal complaint about the conduct. And so the Competition Bureau will accept your complaint. They will do kind of a preliminary investigation into it. And then if they think there's merit, they may open a full investigation into the conduct. And so if the Competition Bureau were to open up an investigation, that's something that, as an IP holder, you want to avoid. These investigations are very expensive. If you have to produce documents, for example, through a Section 11 order, that can cost you upwards of $1 million to be able to comply with the order. And it'll also distract and take up the time of your senior executive team, who would probably rather be focused on growing your business and increasing your profits than responding to the regulator.
So Justine, rather than thinking about remedies available through competition law, let's imagine a scenario where Ben gets a call from one of his clients and they're hot to trot in terms of going to court and enforcing IP and litigating their IP. Are there issues that come up in terms of competition law that might preclude Ben from being able to do that or take that step, or issues to worry about when it comes to competition having litigated IP?
Excellent question. So again, this goes back to the tension between competition law and IP law. So generally speaking, competition law is okay with IP holders litigating to enforce their property rights, except for in certain circumstances where it could have a substantial lessening of competition in a particular market. And so one of these circumstances where the Competition Bureau and competition law is concerned about litigation involving IP is standards. So everyone knows what a standard is. They're very, very common in our society. So if you think about, for example, gas for your car, gasoline is produced to a standard so that it can operate in all cars. Cell phones, Bluetooth technology, a lot of technology today is created to a certain standard so that products can be interoperable. And so the interoperability is really the key aspect of standards. So it just makes our lives easier. And I think that the best example of this is the uproar every time that Apple changes a function of the iPhone. So do you remember when they changed like the headphone jack and the charging jack, and how everybody was upset because you could no longer use your older version of your products with your newer version. So standards are key. They're very essential to our day-to-day life. And so competition law is concerned where IP holders are using litigation in a way that could affect competition for these types of products. So when I'm going through this example, I'm going to use a very standard that everyone in this room will know, and that's electrical plugs. So electricity is used to power all sorts of products. So your coffee maker, your toaster, your fridge, charging your iPhone, and so for all of these products, while there may be more efficient ways to deliver power to them, all of the manufacturers have agreed to manufacture their products to be charged using the standard of our standard electrical socket. And so in doing so, it makes sure that all of these products are interoperable with each other, so it facilitates our day-to-day life and being able to use products interchangeably. So competition law will be concerned with companies that are able to abuse the market power that they've been granted by having their IP included in this standard. So as an example, so consider that Andy has some IP in an electrical plug. So if every device maker or every product manufacturer has to obtain a license from Andy, then Andy has a degree of market power and is gaining rents that he otherwise wouldn't be able to if he wasn't included in that standard. So in this type of situation, competition law would be very concerned about litigation from Andy if he were to sue to stop or seek an injunction to stop people from implementing his IP, because it will have potentially anti-competitive effects in the market. And so this goes to the next point about when your IP has been put into, or you agree to put your IP into a standard, that you need to be making that you're agreeing that you will license your IP to implementers on reasonable terms. So these are referred to as the FRAND standard. So if everyone doesn't know what the FRAND standard is, it's fair, reasonable, and non-discriminatory terms. So if after you've implemented your IP into the standard, third parties, so third-party IP implementers, are seeking to negotiate licenses with Andy, and Andy will only accept very high offers, so very high royalties from IP implementers, his ability to charge this high royalty is based on his market power from being included in the standard. So competition law would be concerned about how Andy's ability to increase prices and the product downstream is derived from his monopoly upstream and the market power generated from being included in the IP standard. And so taking a step back and broadly looking at this, competition law agencies around the world have different approaches to how they will deal with licenses in IP and standards. So agencies like the European Commission have taken the position that patent holders should not be able to litigate or seek an injunction for IP implementers who are willing to negotiate a license in front of a court or a third-party arbitrator. Just last week, the U.S. The DOJ came out with a speech that said that their new approach will be that they believe that these claims should be made in contract law rather than competition law. And so the Canadian Competition Bureau's approach is a little bit more nuanced. And so it still warns patent holders that when they're litigating or seeking injunctions in specific circumstances, it can be a violation of the Competition Act or an abuse of dominance. So these circumstances that you should be mindful of are where you as a patent holder outright or constructively refuse to negotiate a license, or where you refuse to license on terms that are specified by the standard setting organization. So when you agree to put your patent, for example, into a standard, you agree to follow the terms that the licensing terms or negotiation setup that the standard has created. And so in practical terms, what this really means for you and your business is that at every stage of your business planning and business strategy, you need to be thinking about, if I want to put my IP into a standard setting organization, how will not potentially being able to litigate or to seek an injunction against third parties affect my business? And you need to think that through. So like I said, when you're submitting your IP, when you're making the FRAND promise, when you're negotiating licenses, before you litigate, and even during litigation, you need to be aware that you might lose because you've implemented or you've agreed to implement your IP in the standard.
Thanks, Justine. Much appreciated. Ben, you've touched on these issues already, and unfortunately we're running a little bit short on time, but I'm going to ask you to sum up for us some of the best practices for a business in preparing for litigation. What are some of the things that a business can do, practically speaking, to make sure that they're in a good spot if they end up either wanting to sue someone or being sued in the IP sphere?
Okay. So maybe I'll think about one thing for a rights holder and one thing for a person or a company who's defending a suit. So I think from a rights holder perspective, the most significant things you can do that can undermine or weaken your claim is through your conduct when you're licensing your technology. So when you look and say, Andy was talking about your damages is what would have happened but for infringement. And if what you're engaging in licensing your technology, you've kind of crystallized what that value for taking your technology is. You're willing to give your technology for 5% of net profits or revenues or whatever your metric is to Andy. So you're going to have a hard time saying why, if Justine doesn't negotiate a license but just runs off to market and infringes your patent, why you should get 15% from Justine. So I'm not saying don't license your technology, but have a mind to how you structure those deals. And sometimes there's a temptation to think, well, I'm not commercializing this myself, so it's free money, so to speak. Don't think that way. Think about, how am I valuing my patent through this transaction? How am I reflecting what I'm probably going to then be able to get? And doesn't mean that if you do that license that you are going to be deemed to have that rate. What you then are left with in litigation is arguing why Andy's different than Justine and why that transaction was more complicated. And I was actually giving 5% to Andy because I was getting other things back beyond just that 5%. So thinking about the implications for litigation when you're engaging that licensing, then reflecting your thinkings in documents that allow you to convince someone later that that's what you were thinking. That's, I think, the real important thing to recognize as a rights holder. Other than obviously, the more you use your IP, the more harmed you'd be if someone takes it, so the more damages you get.
And then the flip side.
Yeah, so for someone who's infringing rights, foreshadowed this already, one of the strongest, arrows you have in your quiver is this non-infringing alternative argument. that yes, I was found to have appropriated your technology, but your technology is not something that's very special, it turns out. And in that context, recognizing that when you make a decision to enter a market, you're essentially creating a record of why you entered that market that will then be used for or against you by litigants down the road is significant. So the easy example, don't write, oh my goodness, if we don't come in with this technology, there's absolutely no way we'll even be able to survive. We won't make a single sale. If that's true and that's what you're thinking, then yeah, I guess so, but maybe not in like a really great producible document. But if it's not, and people are just kind of speaking loosely in an uninformed manner, that can be really harmful down the road. And it's, I think people are really smart in large organizations about email hygiene from a discoverability perspective in commercial disputes. And as a IP litigator, I would love it if that same sort of hygiene was applied to thinking about market entry, because it has huge downstream risks or reward. And on the flip side, if it really isn't something all that special. So, for example, there's a technology out there that you may be aware of or you really know about, and it makes you incrementally a little bit more competitive, and you're willing to take the risk because you think it's weak, the patent that's out there. That'd be neat to write down, right? It'd be neat to think about that so that when, it turns out that unfortunately you lose that suit, you can say, look, we made a reasoned decision. We had a bona fide belief that this was not a valid patent, but we came to market anyway because we thought we could get a little bit more out of it. That makes it harder for the rights holder to turn around and say, no, you had no ability to enter this market at all but for our great innovation. So it's really just thinking about the arguments you're ultimately going to have to be making, and either being really smart about it or at minimum trying not to be kind of stupid about it. And it's easy to say if you're the only person writing that down, and it's harder to say if you're trying to implement that as a best practice across a large organization. And I guess the last thing that I would otherwise say, if we had more time perhaps in respect of a question that Jordan has spontaneously thought about, is once you're sued, in the same way that when you disclose information publicly, the clock starts ticking on seeking a patent, once you're sued, the rubber really hits the road with respect to this non-infringing alternative defense. Because if you want to turn around and say, it was so easy, I had my toaster pop up with the bread really nicely, but everyone's okay if the toast just pops up a little bit. I could have totally just had a different technology. Do that if you can, because, proof of your ability to implement an alternate technology and not infringe the patent, well, if you do it, that's pretty good proof. But it's a really risky gamut, because if you try and fail, then you've also proven the other side's case. And hopefully if you're sued, you'll reach out to lawyers, but lawyers aren't going to be able to tell you how to alter your product or your service. They'll suggest it, but it's thinking about that right away and kind of engaging in a risk-benefit analysis, both of your ability to design around and how likely you think it is that you're going to lose. That's a really important thing to kind of have on your radar right from the outset.
I'd actually like to just pick up on a couple of your documents points from a competition law perspective.
I thought you were going to be excited about toasters.
Oh, I'm very excited about toasters. Fun fact, I do not own a toaster. Why own a toaster when you can use an oven? And so anyway, from a documents perspective, I just would really like to echo Ben's point about email hygiene and document hygiene. I cannot tell you in the merger context how many times we advise our clients, if you're going to merge, do not write in your documents that once we merge, we are going to take out number 2 and number 3 new competitor. That is terrible. The Competition Bureau does not want to see that. Neither do we. And so, but moving back kind of into the IP context, when you're documenting the importance or significant values of your patents and your IP, and generally, you need to be really careful about the types of language and the types of words that you choose. So depending on what you say and how you value your products, it can demonstrate that you have market power in the particular product. And so this kind of information, so the phrases or the statements you use could later be used against you during a Competition Bureau investigation or an application before the tribunal. And so for in-house counsel in the room, the best practice and my recommendation to you would be when your innovators are creating new products, make sure you go and talk to them early through and continuing throughout the process, so they know what types of things they should be putting in their documents, what types of things they shouldn't be putting in their documents, and then if they have any questions that they should just consult with you throughout. It's always better to address these issues and make sure that you're writing carefully and thoughtfully early on than have something like this come out in discovery in litigation, or to be produced to the Competition Bureau and you're sitting in a witness examination and they pull out this surprise document and say, why did you say this? What does this mean? So it's better to guard against that early than later on and have to defend against it.
Okay, thank you, and thank you to all three of you. I've run out of my questions for the three of you, and so I'm looking to the floor to see if anyone has questions for our three panelists.
I'll start us off. I think there's, you mentioned electronic communications. I think there's a real challenge. One of my clients, a scientist, is leaving, and I know that they had discussions, let's say, broadly about research topics, and they continued to do that up until the day of their departure on a social media channel. You know, so if you could, I'll just throw the question out there. I don't know who on the panel will take this, but what are the added measures, I guess, that you could take or should take as an organization to, you know, NDAs are fine, but you come back from the conference and now you're on a Slack channel or something like that, and you're discussing with a participant about some question that they may have. What are some of the best practice that you can take as an organization to try to the extent that you can, mitigate some potential side effects?
So for the benefit of our internet users, I'm going to rephrase the question a little bit so that they definitely hear it. The question is really, in the new social media age, and with, I guess, the tendency for the ability to communicate a little bit more freely coming out of things like conferences and other situations where your employees will be speaking to employees of other organizations, and they'll be receiving questions about technology and then potentially moving on to other companies. From a legal perspective, from a business perspective as well, what are some additional measures that can be taken to try to control that free flow of information and to make sure that your business is protected? And I think I'm going to direct this toward the end of the table at Mr. Hackett.
I thought you were going to go to the audience. So from ultimately getting a patent perspective, the kind of key take home is that you have to then be very diligent about making priority filings early, so that those sorts of disclosures aren't patent defeating, right? Because if you can't control what your employees are saying, then the best thing to do is to protect yourself early, such that if what they say won't then undermine your patent strategy, for example. That's one side of it. The second is, NDAs are kind of a best practice, but so long as you maintain a confidential nature of the discussion, you still have a common law and patent-based abilities to make arguments that it was otherwise a confidential discussion. Now, how that interfaces on a public forum, makes it awfully difficult. It's really it's unfortunate, but it's really an education point more than it is a legal point, right? If I stood up here and started talking about some great invention that I have, it's no different than if I did that electronically, and the law's pretty clear on the implications that then means for me. It's going to be very hard to say it's a trade secret, because it's not secret. And I'm going to have, as the inventor, a limited time within which I can then make a disclosure. From a protecting yourself point of view with respect to, well, what if there's collaboration through that online discussion and that ultimately leads to something that's patentable, for example? You kind of have to get them on board with trying to say, like, there's a collaboration, there's assignment of right, or you just hope that they don't ultimately, they don't get trotted out as the one true inventor of the patent at the end of the day. And not having all the inventors in a patent doesn't defeat your claim, but you need to have assigned rights from the inventors to be able to actually get damage. There's a QMAX case from about, over a decade ago, where the wrong party was named as the inventor, and that didn't result in invalidating the patent, but the plaintiff wasn't the inventor and didn't have rights assigned from the inventor, so they had no ability to recover damages. So I don't know if that frankly solves the problem, but it's just more to what you can think about. Try and scoop rights and don't say sensitive stuff.
Thanks, Ben. I think we have a question from the internet.
We do have a question from the web. The question is it easier to obtain an interlocutory injunction if the underlying contract, or the NDA, includes a remedy section which includes a consent by the parties to obtain the injunction if there's a threat of infringement?
Mr. Hackett?
That's definitely an IP lawyer question.
Yes, but then you get into an issue about, well, how enforceable is that contractual term? So effectively what it is a recognition of irreparable harm through agreement rather than through proof at the court. And that may enhance your ability. It may be argued that that person didn't fully and knowingly enter into that contract with knowledge of it. If you're unequal bargaining power, you might have contra preferendum, where you say, well, yeah, but that was essentially coerced. So yes, it's better than not, but I wouldn't look at it and say, oh, that's totally in all instances a guarantee. You still have this barrier of satisfying the court that there's irreparable harm. It might be harder for the other side to turn around and say, no, there's not, when they've agreed that there is, but I wouldn't say in all instances that's a guarantee.
I want to thank everyone for coming today. We are running very short on time, so I'm going to take this opportunity to thank Andy, Justine, and Ben for sharing their insights with us, and to thank all of you for joining us. You're always welcome here at Goodman's, and we hold these events quite regularly, and we like seeing the same faces over and over again, and we like seeing new faces. So please encourage your friends and colleagues to join us for our next Goodman's Presents session.